Today we're going to discuss default judgment, and you will find this in Rule 31 of the Uniform Rules of Court. It's not automatic. Default judgment is indicated when a party has failed to file a notice of opposition or has filed a notice of opposition but has failed to file a plea. If the latter is the reason for the default judgment, then a notice of bar needs to be served first, and the DAs need to expire. Now, the requirements for default judgment are that there was proper service, the DAs have expired, you've made out a prima facie case, and depending upon whether it is liquidated or unliquidated, evidence will have to be laid or not. If the matter is liquidated and there's been no opposition filed and there's been proper service, in those circumstances, parties may approach the registrar in terms of Rule 31.5 for a default judgment, provided that it doesn't relate to an eviction or an ejection, something to do with minors, a mortgage bond where there is a primary residence involved, or where you're looking for declaratory or substantive relief. When matters go to court on default judgment, the rules are the same. You need to be sure that there has been proper service, you need to be sure that DAs have expired, and you need to deal with the matter dependent upon whether it is liquid or illiquid. It's important at this stage for us to have regard to Rule 46A. Should a party be seeking to have a primary residence declared executable? Now, the Constitutional Court has enjoined the courts to have judicial oversight over such executions. It is necessary to bring an application and have an affidavit that supports in terms of Rule 46A, and that affidavit has to contain certain mandatory requirements. The first is that the affidavit must disclose whether the property is a primary residence. It must disclose what the outstanding arrears are and any accelerated arrears, the value of the property, the rates and taxes. It must also contain facts relating to whether there has been any other attempt to liquidate the outstanding amount, for example, by the attachment of movables or salary. You must also make sure that in your affidavit you describe what attempts have been taken to give the debtor an opportunity to address the arrears. There must be a proper Section 129 notice and document any attempts that may have been made to restructure or give leniency for the debtor to have settled the arrears, and then any other personal circumstances that may be relevant. Now, it is very important that all of these items are contained in the affidavit for the court to have regard to. In addition to this, Setting a reserve price is the default position. So if you don't want a reserve price set, you need to motivate why. But in arriving at a reserve price, the court is going to have regard to the value of the property, the outstanding rates and taxes, the outstanding arrears, and by calculating all of those, you can put forward a viable and reasonable reserve price. Of course, if the reserve price is not met, you can then return to court and ask for a lower price, the removal of the reserve price, or maybe a sale has or could be concluded but for the fact that the reserve price was not met. Please take note of the fact that a sheriff's report is needed and that there are provisions in Rule 46A as to what should be contained in that sheriff's report. It is very important to remember that if you are going to seek that immovable property that belongs to an individual and is occupied as a primary residence, then you have to make sure that there's personal service of the 46A application on that individual. If you haven't served personally and you've tried a number of times to do that, you can approach the court and ask for other directions for service. There is provision for that in Rule 46A. So what if you're on the other side and a default judgment is taken against you? Well, in terms of Rule 31 2B, you could bring an application to court for the rescission of that judgment on the basis that you can show a good cause, a reasonable explanation for the default, and a bona fide defense. Alternatively, you could bring a rescission application in terms of Rule 42(1)(a), where you would need to indicate that the judgment was erroneously taken. So, for example, if you could demonstrate that you had not received service, that would be a basis for seeking a rescission under Rule 42. Now, the other alternative, of course, is if you can demonstrate that the requirements for your 46A affidavit have not been met. You could challenge it on that basis. The message is clear, though. If you are going for default judgment, make sure that you have met all the requirements, and make sure, if you are trying to execute against property that is a primary residence, that you have dealt with all the requirements in the affidavit in support of your Rule 46A application. It's been such a pleasure to share this pause with you today. Remember, your voice matters. So don't forget to like, subscribe, and tap the bell for the next tea adjournment.